Good afternoon, everyone. I'm Lynn Holtain. I'm the Executive Director of the Victoria Law Foundation, and welcome to our final Research Network event for 2024, this time looking at the conference that was held on access to justice, or the forum rather, in Toronto in Canada in October, where we had a really significant representation from Victoria, and we will hear a number of presentations from Victorians who attended the conference in just a moment. It was a really impressive gathering of academics and practitioners and thinkers, writers in this field, together with the judiciary from Canada, who were in useful attendance as well. We'll get to all of that. And I'm delighted to have with us four presenters who gave papers at the conference: Kristen Walwork, Belinda Lowe, Chris Povey, and Hugh McDonald. And I'll introduce them more formally in a moment. But first and most importantly, the VLF officers stand on unceded Wurundjeri and land, and I very respectfully pay my tributes to the traditional custodians of this country, recognising their abiding connection to this land, to its waterways and community. It's my privilege to pay respects to their elders and to all the generations who have nurtured this land for 50,000 years and continue to do so. At the VLF, we believe that acknowledging the past is an essential step in building a better and more equitable future. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of Aboriginal and Torres Strait Islander peoples. We aim to break down the barriers to justice for all Victorians through our work in research, in education, and in grants. And we are committed to making a sincere and positive contribution to a better justice system for all of us, especially those who are vulnerable and most in need. And I should perhaps just give you a context for that acknowledgement of country, which I don't often do. We wrote that in conjunction with the Wurundjeri Tribe Council, and that process was a really important one for us to position VLF both in terms of country, but also very much in terms of the work that we do. Well, as you know, we are in webinar format, and generally that means that panelists are the only ones who can be seen and heard. So fear not, if you're online, you won't be on camera. But there will be time for questions at the end. And please make use of the Q&A function, and you can upvote other people's questions or put your own, and we will get to as many as we possibly can at the end of the conversation. We are recording today, and we will distribute that after the event. So if you have to leave early, or if you've got other people you think would enjoy it, then there will be opportunity for you to spread it far and wide thereafter. Well, today, as I mentioned, we're looking at the learnings and the insights from the Access to Justice Forum in Canada in October, what we delivered, and the good stuff that we've brought home from that gathering. And first, in the format today, our panelists will speak to the research that they presented at the forum, and then we'll follow that with a short panel discussion on the key highlights that they have brought home from that experience. And I will introduce all our panelists up front so that we don't need to do that through the presentations. And in order, they are Kristen Walwork, the CEO of Southeast Monash Legal Service. As you know, a highly experienced lawyer and social justice leader who has dedicated more than 20 years to serving local communities. And she leads an impact-driven team providing legal support, social support, community development and advocacy for marginalised communities. Belinda Lowe is the Director of Legal Services and Principal Lawyer at the Eastern Community Legal Centre, well known to very many of you are, as I'm sure all of these panellists are. Belinda has worked across the legal sector for 20 years. Again, it seems to be the popular number. Primarily advocating for the rights of victim survivors of family violence and sexual assault, legal representation, law reform, and wider policy and sector reform areas. And Belinda has recently been appointed to the board of Fair Agenda, an advocacy body that campaigns for a fair and gender equal future. So congratulations. Chris Povey joins us too. He's the CEO of Justice Connect, who has also worked for 20 years with and for communities facing significant human rights issues, including people experiencing or at risk of homelessness and mental health issues. And during his time as CEO, Justice Connect has really amped up its strategy and its approach to tackling compounding challenges and crises, particularly through their 2024 strategy. And I think there is a strong future in that, from what I understand of Chris's work. He also serves on the boards of the Australian Pro Bono Centre and the Human Rights Law Centre, and is chair of the New South Wales Legal Assistance Forum. So Chris will join us in a few minutes. And we will wrap our presentations with Hugh McDonald, who, as you know, is Research Director here at the Victoria Law Foundation, a role he has held since September this year or thereabouts. He joined the foundation in 2019 and has worked across all our areas of research, including the Public Understanding of Law Survey, of course, the Data Mapping Project, and the Community Legal Centre's Workforce Survey, which is also a really valuable piece of work. But before that, Hugh has been closely involved with very many different legal organisations, including legal aid commissions and community legal centres, both state and federal governments, and has enormously deep understanding of legal institutions and access to justice issues across the country. So we will wrap with Hugh and then go to our conversation about the key takeaways from the conference. But let's hear first from Kristen, who presented at the Forum on Interventions to Improve Engagement and Understanding of the Justice System in Young People. Thanks, Chris.
Thank you, Lynn. I'm just going to hopefully successfully share. Okay, thank you. We did just do a practice before. I'd first like to recognise the acknowledgement and pay my respects accordingly. I'm currently coming from Wurundjeri land. I am, as mentioned, the CEO of Southeast Monash Legal Service, and I presented on one of our iconic programs, community development programs, which is a youth-based program that runs in a number of schools in the southeast part of Melbourne. This is a multidiscipline program, which I'll go into a bit of detail at the moment. So it was obviously a youth focus, and the program is called Sporting Change. So I won't go into too much detail. I'm pretty sure everyone knows Southeast Monash Legal Service. We've been around for over 50 plus years and well known for our partnership with Monash University and the Professional Practice Program. Sporting Change started about 6 or 7 years ago, and it's based on the idea of engaging young people through the use of sport to allow them to form ideas around law and responsibility in law and engaging in the civil justice system and criminal justice system in a meaningful and productive way. And the areas of laws that we cover are things that are completely relevant to them today. And I think one of the overarching things that I always point out with this program is that the law scaffolds our life from the moment we wake up in the morning to the moment we go to bed at night, whether we're young or young people, very young people, or adults. And that could be catching a bus to school, paying a bus ticket, having respectful relationships in the playground, teenagers having workplace rights, working in the local deli. That sounds a bit old for me. You know, for adults, that's paying tolls, parking fares, having respectful relationships, family violence, tenancy. So all those things are happening every day in our lives. And then obviously we come home. And particularly for young people, it's observing what's going on in the home. Sometimes that's issues in the family, whether it's family violence, family law, family breakdown, debt, that sort of stuff. And we forget that that's all going on for young people. And I think whilst there's things like legal studies in high school, and not enough work has been done in equipping young people and recognising really young people are affected by the law every day. And so that's the sort of genesis and the basis of this program. Involved in the program is our team, which is youth workers, community development workers and lawyers. And we sit within the school. However, we're very separate from the school so that the kids engage and see us as separate. The program involves children between, or teenagers between the age of 13 and 14, committing to 2 terms after school, attending, having an in-classroom, short sort of community development capacity session, and then they go out and they engage in some sort of sporting code. We have relationships with most sporting associations in Australia. They come in and teach a sport and use that as a metaphor. So I'm going to show a short video shortly where you'll see fencing is one that we've used in the past. And in fencing, when you step onto the mat to start a session, you have to consent to it. So we use that for healthy relationships. And then we use soccer for looking at police powers and red cards and, you know, how young people engage with police. And it's been really amazing to see how that sort of translates in the minds of young people and how they remember it. And again, you'll see that in the video shortly. We then have the lawyer that sits on site on the same day as Sporting Change, and that both is the lawyer gets involved in the community development program to demystify and break down, you know, the idea of what lawyers are to young people, but also is an access point for any young person at the school. So these are some of the outcomes we've measured, you'll see on the left. So there's ideas about access to justice. We've had kids engage in getting legal assistance and being able to sort of declutter their lives. We've seen kids being able to do things after school where they feel supported and have a sense of increased identity around what their legal rights and responsibilities are. On the right side, you'll see sort of what we call our unintended consequences. These are social impacts that have evolved out of this program. Some great ones have been the breakdown of social relationships in the school. So we originally were targeting particular individuals. Now we open it up to anyone, and we've seen this emergence of social justice leaders coming through the programs, and also establishing relationships that wouldn't ordinarily happen. We've seen young people who've commented on their siblings being diverted from the criminal justice system as a result of being part of this program, and career opportunities. We've seen a couple of kids that have ended up going to law school, doing social work as a result of being part of this program. These are the sorts of legal issues that we've been assisting our students with over the number of years. I will touch on 2 very brief case studies or case stories at the end of this. Conscious about time. I want to play this little video for you because I think it's a nice little nugget of the experiences that this program offers.
One thing that I learned in Sporting Change was the driving laws, because I'm getting my L soon, so it was really nice to know what ages I'm meant to move off to red piece or apply for my green piece. And my favorite thing about Sporting Change was meeting the new people, like the lawyers.
Something I learned about the law has to be employment. Like, you have the right to ask about your payment and when you want to quit. And you don't have to, like, if you're casual, you can quit on the spot without giving a notice.
I learned that when you're dealing with the police, you can give them your name and address, like you have to.
So that's just a taste of the incredible students, you know, the experiences they've been going through and retaining that knowledge. And so just very quickly in my last 30 seconds, I'm going to touch on 2 client stories. So the lawyer side or the legal side of the work that we've been doing in schools. One involved a young woman who identified as part of the LGBTQI plus community. She got a job. Her boss knew that she had a girlfriend and used that in a very sort of sexually harassing way. We ended up bringing a sexual harassment claim on behalf of that person, and that ended up in a compensation claim of $35,000. The other matter we had involved a young boy whose family had migrated from Indonesia. His mum was in a family violence situation. She separated. She was a single mum. He thought, I'll get a job. He was 15, 16. I'll get a job to help out with the family finances. ended up not being paid, being made to work without a shirt on, really bad occupational health issues. So we recovered unpaid wages and alerted the WorkSafe and the council and a number of others. I'm going to wrap up there. It's a fantastic program, and it was really exciting to present that in Canada to conference. Thank you. I'm going to hand over to Belinda Blow now. Thanks.
Can people see that? Just checking. Great. Thank you, Chris, for handing over. I got the pleasure of actually seeing Chris and her colleague Ash present a more comprehensive version of that project, and I really suggest that you learn more about it because it was really fantastic and something that the Victorian CLC sector is very proud of being associated with. My presentation is in relation to showcasing Eastern Community Legal Centre's work that it's developed over a number of years in its intake and assessment approach. And we call this Eastern Community Legal Centre's Enhanced Entry Approach. For those that don't know very much about Eastern Community Legal Centre, please feel free to scan that QR code there and you'll find out a bit more. So before we get into things, I'd just like to take a moment to provide some brief context and background to the work in this space, and particularly the frameworks, research and understandings that have guided our approach in our specialised assessment and intake program. So to set the context, something that Eastern Community Legal Centre has needed to understand is how intersectionality impacts on obtaining equitable legal outcomes. Eastern Community Legal Centre has learnt to understand that when developing and providing legal assistance services that are person-centred, we've needed to put an intersectionality lens in our approach to providing the required legal support and assistance. So Eastern Community Legal Centre's Enhanced Intake and Legal Capability Assessment is informed by intersectional framework approaches that we try to be as holistic as they possibly can be. So as we know, people who experience inequality often experience compounding challenges. Their problems tend to last longer and often are further complicated if they experience multiple intersectional factors. Inequality in legal capability is central to the gap in justice. How well someone can access legal support is closely related to what they can achieve. To meet people's needs and resolve issues fairly, we need to recognise and address different levels of legal capability. Legal issues often exacerbate existing social and financial challenges faced by individuals. Those of us who work in this area know this very well, and it often creates confusion about where to seek help first. So it's completely understandable that people struggle to prioritise which problem to address first, and therefore it can be increasingly difficult to access the necessary support and resources to resolve legal matters. So a holistic approach to clustered legal problems helps individuals address multiple issues at once, leading to better outcomes by recognising how legal and socio-economic factors are connected, thus providing support for better navigation of the legal system and overall well-being. This is also evidenced in our data. So what you can see here is that people accessing ECLC will on average present with at least 2 intersectional factors which may affect their ability to successfully navigate and access legal help they need. I'll go into this a little bit further later. The Centre also recognises that barriers to access also exist in our own organisations, in external systems and processes, and legal problems tend to cluster. Essentially, if you have an experience of multiple legal problems, you're likely to have more, and with these legal problems compounding with other social or financial challenges, making it even harder for people to know where to get help and which problem to deal with first. So ECLC needs to ensure that our legal assistance approach meets these challenges, particularly at the point of first engagement at the intake and assessment stage. What we try to do at the initial point of engagement is to meet people where they're at. And as recently highlighted in Victoria Law Foundation's Public Understanding of the Law Survey Volume 3, inequality of legal capability is right at the heart of inequality of justice. Consequently, if you want to meet legal needs and resolve problems, you need to understand and respond to diverse capabilities. As we know from the Public Understanding of the Law Survey, individuals who may have lower skill levels, less confidence, and negative attitudes towards law and lawyers are less able to resolve problems independently, are more challenged in obtaining necessary support and less likely to achieve satisfactory outcomes. So unfortunately, what this then translates to is that the problems tend to last longer. So understanding someone's legal capability, particularly in relation to their legal knowledge, ability to self-help, the psychological well-being and willingness to seek help, is important to elicit the right information to ensure that the service provided meets their needs. Otherwise, they're likely to disengage, or the service may be unable to meet what it is that they've set out to come in for in the first place. So what we've found is that this approach helps us to find the right balance in service provision between underserved and overserved communities. The approach focuses on working with a person's strengths and understanding their challenges to identify legal capability and support them into the most appropriate services for their needs. This approach also helps Eastern Community Legal Centre make important decisions in relation to resource allocation as well. So the enhanced intake and triage approach is premised on a no wrong number, no wrong door service model. And we try to make it as person-centered, trauma-informed and multidisciplinary in practice as we can, but we are constantly learning. So and what we do recognise, as I've mentioned earlier, is that people who experience marginalisation or complex life challenges face many barriers. In these times of change, what we've noticed, of course, is that asking the right questions periodically is critical and can change everything. Because of course, the questions we ask will ultimately produce the answers we get. So the Legal Centre's journey into understanding data insights has been about uncovering the experiences that lie beneath the surface. Eastern Community Legal Centre constantly reflects on why we do what we do to really understand the profound consequences of not doing it. This means asking the following questions. Who are our clients and what are the intricacies of their needs? What barriers stand in their way when they seek legal help? And most importantly, how effective are our services in meeting those critical needs? Now, don't panic. I've got a few sort of graph sort of slides, but there's just a few examples of how we collect and use the data to inform resourcing and service provision. This graph here shows the multiple intersectional factors that our clients present with and the complexities of service provision for priority groups. And this graph shows different types of people getting different types of services. And so what we can see here, based on an individual's capability assessment, is people with little to no intersecting factors and strong capability to manage the legal problems are provided with the referral pathway support. However, across the centre services, we are now seeing an increasing trend in assisting people with multiple intersectional factors, generally between 2 to 3, with more disadvantage and less capability to self-help. And they're provided with more complex legal advice services and representation. So these are a list of the key changes that we have implemented in our project, and please feel free to scan this second QR code to find out more about the project. And this slide shows our key focus areas as parts of our continuous improvement, which we always want to continue to commit to. Thank you very much, and I shall now hand over to Chris Povey.
Hi everyone, I'm Chris, I'm CEO of Justice Connect. I want to acknowledge the Wurundjeri Woiwurrung people of the Kulin Nation. I'm on their land and what a beautiful day it is today. I'm going to be talking about 4 things, and this is kind of going back over what I talked about in Toronto. So a little bit about Justice Connect, talking about disasters and legal needs, some of the context there. I'm going to provide a bit of a case study about what that means for Justice Connect and what we've been doing. And I'm going to touch on briefly a list of projects that we've been involved in at Justice Connect that relate to disaster need and trying to meet some of the need here. So one of the things, by the way, that I learnt just getting into the learnings early, Lynn, about while I was in Toronto was there needs to be some relationship between your slides and your prepared comments. I'm not big on preparing slides, or that's not my skill set. Somebody assisted me with that. And then when I got up in Toronto to speak to it, there was kind of a bit of a mess, really. It was not seamless. My comments had no relationship to my slides, but I've tried to improve that for today. So I've updated, and I think you hopefully will be the beneficiaries. Here, who do we work with? The purpose of this slide is really just to show a little bit about the scale of the work that we're doing and the range of different groups that we're engaging with. Next slide here. This is a dense slide to channel Belinda from before. Numbers. The point of the slide really is our starting position is that legal need is unacceptable. The VLF research, which is outstanding, I recommend the VLF on that, and more about that later really, but just points to a massive amount of unmet need. And in our experience at Justice Connect, this need is growing rapidly. I heard yesterday that 10,000 people are becoming homeless a month on top of existing numbers. We know that legal support is not keeping pace. National access to justice, additional funding is not going to touch the sides. So one of the things that I talk about when I talk about Justice Connect is nose to tail justice. So this idea of eating the whole animal, eyeballs and fingernails. I know it's not a really vegan friendly analogy. I looked at ChatGPT, tried to get some support. Root to leaf, bean to pod, just doesn't have the same kind of ring to it. Point being, it's about stretching help, right? So you have high intensity support, integrated partnerships, health justice partnerships, place-based support, criminal lawyers, civil lawyers, social workers, delivering higher intensity support to the people that need it most. And then you stretch that help into providing information that can reach many, many more people, information and tools. And hopefully, if you look at this slide here, service provision, you can see how much individual services we're delivering. And then you can see the self-help views to resources, views to tools, and so on. And that's something that we're really keeping an eye on, just to come back to something that Lynn was talking about earlier. Our approach, I'm not going to go into this slide all that much, but this co-designing point is a really important one for us. We have a major corporate partnership, and the partner said to us, "Oh, why is it taking so long?" And fair play if it was taking a long time, and I didn't think that was in fact fair or true. Really, what we're doing was we're talking to people. We wanted to know what they wanted, what they needed, and we know that that's how you build something that works, right? Building something based on those insights. And I think, you don't always see that, and it's such an important part of the work that we do, and it's what the research says we need to be doing. So disasters, just a couple of points on what we know about legal need and disaster. I've just pulled out, there's an increasing body of research in relation to this, but we know that disasters create a surge in demand and complexity. Natural disasters, climate disasters can create new legal problems and make existing problems worse. There's a long-term impact on legal need. So this long tail of need, we are still seeing legal need arising from disasters that have happened years ago. And then we know that there are specific challenges for legal services, including destruction of infrastructure, so impacting courts and legal services, the impact on technology and communications infrastructure being out. We also know from direct experience that there are significant funding constraints, and I think disaster funding is certainly an area where there's a bit of uncertainty. One of the things that I wanted to touch on, this pro bono portal, I just want to talk quickly about. In 2009, I was at Justice Connect in a different role. So I was in our homeless law team, and at that point there were the Black Saturday fires. And I remember everyone's like, "Oh my God, this is a disaster. What are we going to do? We want to help out." We ended up, there's a group of people that got onto a roster when we went down to a community hall in Healesville, and we wanted to help people. And so they were slow days, right? So we were sitting around while we watched people go to housing support, food support, clothing support, lawyers, not so much. And that reflects, for me, one of these structural things that we know, like in the immediate aftermath of a climate disaster or a disaster generally, we know that lawyers are not necessarily top of the list, but that comes later. So, consistent with the research, disasters generate significant legal need. It takes a long time, but it can persist for years. But for Justice Connect, we're about providing assistance to a range of different people in different ways, but people come to us for help, also for connection with pro bono. So this is a call-by-call process, at least in 2009. So people contact us, and then we try and phone around, send emails around, trying to connect them with a firm that might be able to help them. It's very manual and highly administrative. And on a sector basis, coordination of pro bono as a part of access to justice that can deliver more help is tricky, right? Because many want to help, but the process is uneven. It can be fragmented. So 10 years later, I was also at Justice Connect for the Black Summer of 2019, and there was a mega fire. I mean, most of you would remember it was like something out of Blade Runner. The sky was orange for weeks and weeks, a state of emergency for almost 6 months. Tens of thousands of kilometres were burnt, more than 30 people died, and I think hundreds more from smoke inhalation, millions of animals, thousands of buildings burnt to the ground, an absolute catastrophe. And what we saw in the profession was incredible. I think lots and lots of pro bono lawyers and CLCs wanted to help. And just talking about the kind of pro bono part of that for a moment, the risk is individual approaches to communities that are in crisis and confusion and delay. At that point, we had developed our pro bono portal, which you see up here on the screen. People can apply online. Their matter can be placed onto a portal, and then we have all of our firms browsing that portal, and they can pick up and take matters. We have about 10,000 lawyers in our pro bono network, and last year we placed about 700 opportunities with private firms. We've also got community legal centres on the portal, and they're using it to make direct contact with firms to place their own matters. There's a range of other things here that we're doing. So we've got a disaster support resource hub that has more than 70 resources. It's been viewed 20,000 times. Diagnostic AI. So this is about helping people pinpoint what their legal need is so that they can then get access to legal support that provides help for their actual specific issue. If you can't identify what your legal need is, you can't get help with it. Get ePrepared. This is helping people with low digital literacy to prepare for disaster, so to store their key documents. That's been viewed tens of thousands of times, and we've been tracking the impact of that, and it's helped people build new legal skills and digital skills. And this is about helping people ask individual questions. That's everything for now. I'm going to hand over to you, Hugh. Looking forward to hearing more of your amazing research. Thanks, everyone.
Great. Thanks very much, Chris. Well, at the forum, it's probably no surprise, but I was presenting on our Public Understanding of Law survey, a presentation entitled Legal Need and Legal Capability Really Matters, presenting some new findings from the Pulse. The session I was in was entitled Legal Advantage and Vulnerability, and it was actually a really great fit for the for my presentation and the material in that session. And I think thinking about legal need and capability of two sides of an advantage and disadvantage, or higher and lower vulnerability sort of coin is really useful. So the session provided an important take on legal capability, pulling together factors that contribute to positive legal behaviour, or as Emily Taylor Poppy put it in her presentation in the same session, how some people are better equipped with skills and knowledge to engage with law and behave strategically, and how legal knowledge and capability are mechanisms of advantage that often drive inequality. And that's exactly what we see in our findings. So the Public Understanding of Law survey clearly shows that in addition to legal matter and demographic characteristics, which are well recognised as being two drivers of legal problem experience and behaviour, well, as Blenda's already alluded to, legal capability also really matters. It's another layer of inequality, and it's pivotal. It affects how people behave and what they get out of the justice system. And the Pulse findings really provide an important new perspective on legal need and in effectively meeting that need. I'm not going to go into too much detail about that today, but the Public Understanding of Law survey has its own website where all of our reporting is available, along with some technical and guidance material, and the data sets even available if you're really keen to get stuck into it. But really shortly, or in short form, Pulse is a representative survey of 6,008 Victorians examining their legal need and capability, and importantly, the nexus between that. So what we did in the Pulse that's new is operationalise several measures of legal capability. First, to examine how that's distributed across the community, but importantly, secondly, how that's associated with legal problem experience, behaviour and resolution, including how it's associated with legal problem duration, and importantly, with met and unmet need. By the term legal capability, I'm referring in how it's defined in Pulse as the freedom and ability to navigate and utilise the legal frameworks which regulate social behaviour to achieve a fair and just resolution of justiciable issues. But as many of you are well aware, legal capability is a multi-dimensional concept, and it's commonly and widely used to refer to knowledge, skills, attributes and resources needed for someone to have an opportunity, as Chris alluded to decide whether and how they want to engage and make use of law and the justice system. So in Pulse, we developed several measures of legal capability, tapping into the knowledge, skill and confidence dimensions of legal capability, as well as some measures tapping into attitudes to law. We used all of those measures to also develop some composite measures. Again, I won't go into much detail about that, but that's all in the reporting. But overall, we saw really strong social patterning of those measures of legal capability. They were associated with certain demographic groups. That's reported in volume 2 of our reporting. But in our latest volume, we go much further and examine the relationship between legal need and capability. And what we found there is that, legal capability really does matter. And in many cases, it's powerfully so. So when it comes to what people do, whether they took action, their ability to handle things alone, whether they used informal or independent or legal help, whether they were involved in legal processes such as courts and tribunals, whether and who initiated processes, or whether people were on the receiving end of law and processes, how long legal problems last, whether or not people were able to get all the help that they needed from the legal and justice system, and whether or not people were satisfied with the outcomes and progress of their situations, and ultimately whether their legal need was met or not. Well, legal capability typically made a significant pivotal difference. So overall, the findings really provide an important new perspective on legal need and access to just resolution. Legal capability is advantageous and should be seen as another layer of inequality in access to justice. So these findings once again point to the importance of matching services to need, where those with lower skill, confidence or more negative attitudes generally being less able to handle problems by themselves. And when they reach out to seek and obtain assistance, that what they're receiving tends to be less adequate for them in their situations, and contributes to unmet need and worse outcomes. So yeah, taking capability seriously, we think can really help to ensure that the justice system doesn't amplify the advantage that some people have. So being mindful of this sort of asymmetry of legal capability across the community, again points to the dire need to move to more people-centered approaches to justice. Again, has already been alluded to in the earlier presentations today. As we know, many services are already doing. So taking legal need and capability seriously, we think is a really important pathway to improving access to justice for the community. I think that's me. Over to you again, Lynn.
Thank you, Hugh, and thank you to Chris and Linda as well for all your presentations. I think there is an enormous amount in all the presentations that we've heard, and with your permission, and please let us know if I've overstepped here, we'd love to be able to distribute your slides if you're okay with that, with the EDM of this video. So particularly, Belinda, people have got 2 seconds to actually take down that QR code and use it. But let us know if that's a problem and we'll find another way, because I think there are enormous resources in sitting behind all your work, and clearly it was skated over very quickly today, because it was I think really important for us to give people in Victoria a sense of what we learned, what we took away. But first, I'd really like to know how your stuff was received. And Chris, I was thinking of this when you were talking about Sporting Change, because I mean, it's such a remarkable project with such extraordinary outcomes. Did you, I mean, I imagine it was extremely well received, but was there anything similar that anyone put to you, or was this quite novel to the international audience that you were presenting to?
Thanks, Lynn. Yeah, it was really well received, and a lot of people came up afterwards asking about it. I think there was one other project that was presented around youth. I think the takeaway, though, for this is a couple of things. One is, just as a broad statement, I think there is a greater, even though we never have enough resources, I think the reality is that resourcing in the Australian context is a lot greater than other contexts. And so it allows programs like Sporting Change to be seeded and to grow. And I also think I think there's a different complexity of environment that allows a program like this to grow. So no, there was nothing else like it, but I do think it really speaks to a lot of what the Australian representatives were presenting at that conference. So
one of your takeaways was validation, really, about what we do and the fact that we're in a position to be able to do it.
Yeah, and I think a number of presenters I saw commented on that, obviously being involved in this conference and others in the past, but there's a real sort of looking to Australia and how we lead in a lot of particularly legal aid assistance sector. And I you know, yeah, I think it is validation about what we're doing and how we do it.
Yeah,
that's not to say that government shouldn't fund us.
Exactly. Not at all. We'll never suggest that they should do anything except fund us to a greater extent to help more people, because I think as you have all, and certainly Hugh and Chris have pointed out, you know, the legal need is eternal, and that's in your data too, Belinda. Chris Povey, tell me about disasters, because I mean, this is a universal phenomenon. Canada itself had been through horrendous wildfires not long before the conference, a few months before. And, you know, there is a significant focus, I think, around the world on the impact of climate change and climate disaster in particular. What was the response to your presentation?
Good question. It was on the last day, and then partway through, a fire alarm happened. I don't know if you remember that.
Yeah, I was chairing the other session.
There you go. So there was panic. No, I'm kidding. There was no panic, but it was a bit hard to get a read on that, I suppose. And I think my take on this part of legal assistance reflects my general sense of, quite often in a range of different areas, legal need is an afterthought. People don't necessarily recognise that it impacts your health, your housing, your family relationships, your financial stability. And so when people think, oh, climate disaster, they don't immediately think, oh, what's the legal need that's going to come out of that? This group, I mean, one of the reflections for me going back over my notes, there's such a diverse set of interests. So you're looking at people who are dealing with courts or with pro bono or with disaster or with young people and legal education and so on. I think that is one of the richnesses, the richnesses plural. Anyway, part of the richness of the conference and part of the challenge about how do you dig into it. So I think to answer your question, there were some sort of specific things that made getting feedback about my presentation and our work a bit challenging. I think there is interest, but I think more generally, the awareness of this and the relevance of legal need, we've still got a way to go.
Yeah, I think that's fair comment too. B, you gave a very strong presentation around, you know, practice and around the specifics of frontline service to a conference which, as Chris has just pointed out, was pretty diverse. There was judiciary, there were, you know, lots of academics, and there were also some others like you coming from the practice sector or segment, if you like. What was the response to you, and what did you learn? Were there other people who presented similarly around the nuts and bolts of identifying legal problems and responding to them?
Yeah, I think that there were some sort of variations of direct practice presentations that I saw, but none, at least none that I was able to observe, that sort of spoke about the measuring sort of and quantifying like your impact, like through, you know, through collecting data, which was which was the focus of the presentation that Eastern Community Legal Centre did. And to be honest, I was really surprised that it was so well received, just because I assumed that it would not be as well received, because I assumed there'd be lots of academics and, you know, people there that would be thinking in much higher levels. So not that I went in thinking that, you know, we were like less or anything like that. I just was very curious as to how the delegates, you know, would be represented. I found it really interesting, Lynn, that a number of different delegates across the different countries wanted to speak to Eastern Community Legal Centre in relation to how we do continuously try to improve our the ways that we collect our data, particularly at our frontline services, to be able to really respond to the ever-changing needs of our communities. Not so much the Victorians or Australians, of course, but certainly those from the UK and the North Americas. It was very enlightening to me in the sense that I you know, echo Chris Warwick's words in that Victoria seems to be quite well advanced in relation to the different ways that we are able to respond to access to justice needs. So they don't have to be just a lawyer. They're providing advice on individual matters, and you know, there can be a range of different ways, like community engagement, community development ways that Victoria has been able to be flexible enough to be able to do. And yeah, it was one of the key takeaways for me. It was very interesting.
I think sometimes we tend to think, if you're in one sort of cohort of the sector, either academia or frontline service delivery, you tend to be in awe of the other.
I am terrified of academics, like,
well,
you know, I'm very scared of you.
I think the upside is that, Hugh, it seems to me that the academics are often completely blown away by people who actually do this work and who are seeing clients every day and resolving issues and dealing with huge and unrelenting legal need. In sitting behind a lot of, well, certainly our presentations and referenced in many others, and not just the Australian presentations either, was Pulse. I mean, I think we got a sense of how well regarded Pulse is as a piece of work, and that it now has a global resonance as the first time that legal need and capability have been measured at population level in this way. Was that the feedback to you?
Yeah, absolutely. So my circumstance was a little bit different to probably Chris Povey's. So I was on day one after lunch before the reception. There was a significant period of time at the conference reception while we were all standing around waiting for the Attorney General of Ontario to turn up and grace us with his presence, where I was just inundated with people from all over the world that wanted to talk. Pulse wanted to talk. the findings, wanted to immediately apply them to things that they had been working on. And yeah, it became clear to me in that circumstance that Pulse and the work had already made its way into the syllabus of several university courses. And yeah, it's given a tremendous interest in the work and in following the work and applying it in other places. And I think, I mean, part of the real value of the work is its crossover with practice and its tangible insights for practice at a time when a number of places in the world are probably struggling with even more dire situations than we find ourselves in, and struggling to keep access to justice turning over.
So Hugh, given that you presented, pretty much an academic paper in large part, or certainly about a very substantial piece of research, and this is, you had a lot of very interested people and peers. You've been to these conferences many times before. What did you take out of this one? What was new for you?
New for me was a clearer insight into how the challenges around the world are very similar, and how some of the new thinking around people-centered justice approaches, but in particular, a phrase that was quite common in the several of the presentations was pinpointing onto the difference that community justice workers can make to access to justice, which is something that we've sort of referred to in other terms in Australia. So we've spoken about problem notices, trusted intermediaries, community services, and working in partnership and joining up and those sorts of things. So it's something that's really familiar to us, but is something growing in striking acceptance and realization in other parts of the world. And so perhaps one of the things that I was really struck by was just how often there was a presentation from somewhere else in the world around a service model or a way of working, or some of the research insights, where I'm sitting there going, well, we already do that. And we've been doing it in Victoria for a substantial period of time. So it's kind of really striking that it's and reassuring that we're on the right pathway to working well and making a difference. So yeah,
that's certainly strong in my recollection as well. P, we've had a question which works really well with this idea of community workers and community legal workers, from Ruth, who's wondering about whether or not court network people can access the pro bono portal, which I think is a very direct and very useful question to put. I don't know if you want to take that on the spot, or maybe we can connect you and Ruth at some point.
Great to have the question, Ruth. Thank you. Short answer is no. And the one of the challenges is, if you work in pro bono, is family law is a real gap. And we often work with commercial lawyers, effectively, who can do certain work and also can be supported to do certain work. Family law quite often is, or we know just generally, it's a massive gap. Currently, the portal isn't really used for that. I think in terms of court network, interesting hearing you talk, Hugh, about intermediaries and community services and so on, who are the people that make those connections. Court network absolutely are in there and have such a key role. I think there's probably a range of different tools that we use, but also that we could develop that would support court network in their role. So I think, so the short answer is no, but I think maybe.
And ...
Yeah, one of the things just I wanted to add as well, Lynn, was I'm interested in your perspective on the connection of research and practice-based responses. So for me, sometimes at the conference, you had these amazing sets of data and kind of very deep analysis and so on, but it was kind of like, what's the real world impact? I think we are very privileged in Victoria to have VLF that not only does the work, but thinks about the connection between the work and the practice. And this event today reflects that. One of the things I saw at the conference was people going off into the distance with all this kind of data sets, and I didn't see how that would come back. How it would connect with changing kind of the work that Chris or Belinda or I do kind of day to day, which is, I was interested in your reflections on that.
I think I would absolutely agree. And I think there are some exceptional people in this sphere who work very diligently on very clear questions about access to justice in very theoretical terms. And that's not to in any way undermine their intent in terms of its usefulness, but it's not the pool they swim in. So, and they're not particularly close to service provision. And I think, I mean, Hugh would have a view on this too, being closer to many of the people that I'm thinking of than I am. But it is a privilege for a research organisation to have the sort of relationships and access that we do in order to make sure that what we do is useful. And it's not a common phenomenon, from my understanding at least. Hugh, did you have a further view?
Yeah, I mean, there are some academics very entrenched in their own, like they would probably refer to it as their clinic services.
True.
Some that might be doing strategic litigation, some that may be taking their university class and doing real world work with them. Often that's in the jurisdictions where maybe they don't have as much provision of public services in particular. So it's kind of like their personal commitment to access to justice work because they feel like they have to. So, I mean, one of the areas in which Australia has sort of been regarded in the past is they sort of refer to it as the Australian model of legal assistance service, public legal assistance services in particular. So we have a few more pillars than some other places in the world do. And one of the standout one is our Aboriginal and Torres Strait Islander services, which do not have a similar established network of services and funding of services in other parts of the world. So Australia is kind of looked at as being at the forefront and the leadership of some of these issues. And going hand in hand with that is a lot of other countries look really enviously on our community legal sector services across the whole country.
That's very true. We've got just a couple of minutes left, so I'm going to open it up and ask all of you to give us any of the further takeaways that you took from the conference, because I'd be really keen to make sure that we captured as many of those for the people who are watching today. Chris, did you have anything to add? Chris Walworth?
I just found my notes from the Chief Justice, and I really loved, he talked about civil education and sort of obviously lines to what I presented on, but the fact that this is what I've written, that we don't respect institutions anymore because we don't understand the value and importance, and we need access to justice is about building that bridge and the common ground so that people understand the rule of law and how it unites our society. And I thought that was really important because sometimes we're often just sort of, how do we bring people to water? But they need to understand, they need to drink it. Terrible metaphor, but that's my last words.
Up there with nose to tail, which just generates an image in my head, Chris P, that I will never get rid of now. Thank you for that. But the role of the judiciary in other parts of the world was really striking. And I think particularly in Canada, because they were our hosts, and as Chris has just mentioned, the Chief Justice opened the conference, the Attorney General hosted the reception, and then the Chief Justice just rocked up at another session entirely unexpectedly because he was interested in the content, and one of his other judges was presenting. But it was clear that the judiciary and the bureaucracy, or at least the ministry, were really engaged with the high-level concepts around access to justice. They got it. They talked the language that really resonated, I think, certainly with us, and that's something that I'm not sure we would get in such spades from our judiciary here, but maybe or certainly some of them are pretty good on it, but not all. Chris P, did you have other stuff that you wanted to pass on?
I'm really interested. Thanks, Lynn. I'm interested in the access to justice area, the concern about the risk of technology versus the opportunity of it. I think there was a big session where there's a lot of doom and gloom. You got to go deep into developing a policy, and that's fine. Don't disagree, but also really, really concerned about the people who are missing out and what it means for them. And quite often the conversations for me seem to land on the risks and the disaster of it. That was something that I'm just observing and I'm interested in. I really loved Tanina Rostain's, as she said, diatribe
Yes.
that she tried to turn into a paper about the pro bono industrial complex. If you think about the role of Justice Connect and, the relationship that we have with pro bono, which is a very strong and deep and long-standing one, it's really good, I think, to hear challenge and to think about and reflect on what that means. She talked about the crisis isn't about insufficient lawyers. It's a fundamental and systemic and structural problem. 70 to 80% of problems don't get resolved. People of colour are the most impacted. It's a disproportionate impact. So individual help, which is the focus of pro bono, is not where the effort needs to go. It needs to be on systemic responses, and pro bono is less well placed to respond to that. So she talks specifically about pro bono has an important legitimating function for corporate practice. What have corporate lawyers been up to? Capital doesn't come into being on its own. It's created by lawyers who code certain assets as having values. Lawyers create new types of structures to allow concentration of wealth and value. I found that a fascinating take. I think it's kind of like, it's super interesting and it feels true in a sense, and kind of, so what? Well, how is that going to change anything is a question for me. Like, you can complain about it, but it doesn't, short of revolution, it doesn't feel like her diatribe or paper is going to change it. I mean, one of the things that I'm most interested in is what is the impact of pro bono? What is the effectiveness of it? Complaining about this kind of structural stuff, I think there is a role for it, but and it's interesting, but it's kind of, it doesn't feel like it's going to change things.
I was in both the sessions that you've just alluded to, the first being the sort of very deep dive into AI guidelines and processes and stuff, which was a bit mind-melting, but and was absolutely, I think, a turn-off to applying some of the more valuable dimensions. And also Tanina's presentation, which I love for all those sort of provocation that it generated. But to your point, I think there is room, as always, on the spectrum for the bomb throwers and the people who are actually going to make this work. And your very generous take on accepting her provocation as useful. But I mean, it was a wonderfully sort of socialist and almost Marxist perspective, which was great to see at a conference, because I don't think you get that kind of content that much anymore. One of the days when those were the people that populated these sorts of events. Linda, do you have anything that you wanted to finish up with?
The only other sort of really interesting takeaway I had, well, interesting to me, may not be interesting to anybody else, was sort of going back to something that Hugh said earlier today in relation to what we know in Victoria as, a growth and big development in multidisciplinary and integrated sort of practice work, using our using the skills and expertise of so many professionals to wrap around an individual to assist them to navigate, their issues through the legal system. And in the other jurisdictions, such as US or in Canada in particular, what they saw as an access to justice issue that seemed to be aligned but wasn't quite the same was, seeing that there was a there was, you know, a lack of resourcing for lawyers, and therefore a way to potentially fill that gap so that people could get legal advice and assistance was to go to professionals who were not lawyers or people who were not lawyers, and for them to looking at ways that they could provide legal advice, which was quite different from the way that we would sort of look at multidisciplinary and integrated practice work. And it was very challenging for me to hear as a risk-averse lawyer. It was also very interesting as well. And yeah, I'm just still mulling over what that looks like, and is it a way to go for the future or is it not?
Very interesting question. I think we've got a whole research network event on that one because context is everything. I mean, there was one example that is often cited about Alaska and how they engage health workers and skill them up with legal knowledge and referral pathways to assist in very remote parts of the world, which seems a very sensible response to a particularly challenging environment, physical environment. So, you know, there are horses for courses. But yeah, I think all the machinations around how you get permission to offer certain kinds of service or advice and what's appropriate and what actually responds appropriately to the bottomless pit of unmet legal need, I think is something we all need to consider. I think sadly we have to draw it to a close, but I appreciate enormously the contributions from Kristen Warwork, Chris Povey, Belinda Lowe and Hugh McDonald. Thank you all so much for sharing what you gave and for describing what you took away. We will put the video of this session up, so if you would like to watch again or if there are other people you think would benefit, then please feel free. There is also, just as of today, the full set of the videos from the conference have just gone live. So in our EDM on this session, we will attach a link to the conference videos so you can for yourself see what happened there, and you can watch Tanina Rostain blow apart the pro bono industrial complex. And also the Chief Justice of Ontario speak incredibly powerfully about the need for appropriate responses to legal need. So thank you very much indeed for being with us for this whole year of Research Network events. We'll be back again with Bells On in 2025. And we wish you a restful summer break and safe home. Thanks for coming.